Andrew Weissmann, recusal of Judge Chutkan. This is a decision for the judge to make herself. Again, this motion seems to be a very well-argued motion, isolating these two comments that she made in sentencing of January 6th defendants.
Well, I'm going to disagree with you about well argued. If you are going to make this motion, first, it needs to be made timely. You don't get to sit on your rights for 6 weeks, see what the judge does on your effort to delay a trial date. Then when you don't like that ruling, say, you know what, now I want a different judge. And that's why the law requires these kinds of recusal motions to be made at the very first instance. Instead of playing games, which is what happened here. Second, judges are allowed to, at sentencing, express views about co-defendants. That's all that happened here. There is nothing that you have read that is not 100% true and accurate. And then finally, it is really hard to be talking about recusal when we're sitting with at least 2 Supreme Court justices in situations that actually call for recusal who are not doing anything whatsoever. That's Justices Thomas and Alito. And the idea that Judge Chutkan should recuse herself based on valid comments made about co-defendants at sentencing, where the federal sentencing guidelines call on judges to make these comments at sentencing, really, to me, is beyond the pale and shows, to my mind, that the lawyers are not exercising any control on their client.
But, Andrew, Donald Trump wasn't a co-defendant at the time the judge made these comments.
Yeah, but that doesn't mean that you can't look at the facts of what happened. And he is, for all intents and purposes, he is a co-defendant now. And so when you have a case before you and you are at sentencing, you have to describe for the particular defendant why you are sentencing the person to a particular time, why you are accepting arguments, and why you are rejecting arguments. That can involve other people who are charged and people who are not charged. So there's nothing about what she said that's improper. It's actually important for her to say why she is accepting things. Nothing about the 2 statements that you read in any way, to my mind, mean that she cannot be fair, or even an appearance of impropriety or not being able to be impartial.
Neil, that's the appearance point is kind of the most important in a way, and that's the one that the lawyers lean on the heaviest. They grant that it is entirely possible that the judge believes that she is impartial and will absolutely try to conduct the trial in an impartial way. But they say that there could be a very large perception out there that she is not fair, that she is biased because of these statements.
Yeah, Lawrence, I mean, it's not surprising in a way that Donald Trump is making these kinds of arguments. I mean, Judge Chutkan is Donald Trump's least favorite kind of judge, an honest one. And when we talk about the appearance of impartiality, I think there are 2 problems with it, and both Andrew has pointed to. One is, if you have an impropriety, you don't get to sit on your hands for 42 days, which is when Judge Chutkan was assigned, participate in a bunch of proceedings, and then decide you don't like them, and then try and seek a new judge. I mean, these statements that Trump is pointing to were made in 2021 and 2022. They're not like things that she just said. And so I think that removes the appearance issue, because if anything, the appearance is of an improper motion occurring after the fact. The other thing that Andrew was getting at is that these statements are made in court all the time. Indeed, 10 different judges in Washington, D.C., 10 different federal judges, Lawrence, have made similar statements about January 6th defendants and Donald Trump. Judge Bates, who is one of the most respected judges in D.C., former Whitewater prosecutor under Ken Starr, said something similar to what Judge Chutkan said. Judge Kollar-Kotelly, another one of the most respected judges, she said the following, quote, "At the Stop the Steal rally, President Trump exhorted his supporters to, in fact, stop the the seal by marching to the Capitol. So you've got a bunch of different statements by judges already. And I think this is something that the Justice Department and Jack Smith, the special counsel, understand really well, because you can remember all the things that Judge Cannon did last year in the stolen documents Mar-a-Lago thing, actual rulings made about Donald Trump that are wackadoodle and slapped down by the Court of Appeals. But you didn't see the Justice Department going and crying and saying, oh, we need a different judge, appearance of impartiality, things like that. They understand the threshold, the standard is very difficult. They didn't file such a thing. And I think, here it's unfortunate that the lawyers did file such a thing, but I don't think it's going anywhere.
Andrew, so the judge makes this decision herself. If she decides not to recuse, will the Trump lawyers and can the Trump lawyers appeal that decision?
They can try to. It seems unimaginable to me that a panel in the D.C. Circuit, even with the most sort of pro-Trump panel, is going to do this. You have to remember, Judge Chutkan is so well respected, and the precedent it would set in these kinds of cases would just be untenable. I just think when you have a recusal motion, it's very hard to win. I don't think that Donald Trump's lawyers actually think they're going to win. When I read this motion, I thought it was for the MAGA base, and that's where they want the appearance to be that she's unfair. I think that is the audience. I don't think it's for Judge Chutkan or the D.C. Circuit. And that's why I said I think that this shows that the lawyers are really not in control. If they ever were, this is the kind of filing that you just don't make, and you don't make it at this time.